All right, I'm Stephen Thrasher with the Village Voice Run and Scared blog, and I'm talking to Chris Geidner of Metro Weekly and the Polyglot blog. I think I'm saying that right.
Yep.
And when I don't understand what the Obama administration is up to legally, I read Chris's work. It can be very complicated to figure out. So I thought I would ask Chris for you to tell us a little bit. Just kind of, walk us through, where is the administration right now on same-sex civil rights? I have some sense of where they are politically. I think whether people are upset or frustrated or happy with the president, they kind of understand how he's hedging his bets, whether they agree with them or not.
Right.
But I really don't understand legally what's happening, and you've had some good writing on it. So kind of walk us through where we are right now.
Well, I mean, where we've gone over the course of the past 2 years is really from a place where the lawyers who were working on the case were on the cases challenging DOMA were basically the same lawyers who had been doing it at the end of the Bush administration.
Mm-hmm. So they were not political appointees; they're just career.
Well, they were. One of them started during the Bush administration. One of them, but they were not specifically political appointees. Mm-hmm. But after the first brief in the Smelt case in California, I think that that was the one that had some of the most overbearing language and used a lot of extreme arguments. It was after the uproar following that in the summer of 2009, Justice started to look at the cases more carefully and present a more nuanced argument. And one of the arguments that they disclaimed right from the beginning then was the idea that DOMA helped encourage child rearing by heterosexual couples, and Justice disclaimed that as a valid reason. But then on February 23rd, the landscape changed dramatically because the administration decided that both Attorney General Holder and President Obama decided that they had concluded that Section 3 of the Defense of Marriage Act, which is the federal definition of marriage, was unconstitutional because they found that all sexual orientation classifications in the law were subject to heightened scrutiny under the Equal Protection Clause, which means basically that courts looking at any classification based on sexual orientation, according to the administration's view, should view them skeptically and presumptively find them unconstitutional unless they can show that it is serving an important interest.
So the president and the Attorney General made the decision. Attorney General Holder sent a letter to Speaker Boehner. The House then decided to continue defending this law.
Yeah, the House Bipartisan Legal Advisory Group, which is the never before heard of and probably never again heard from. It's five members of the leadership, 3 now currently in Republican and 2 Democrats. Both of the Democrats, Minority Leader Pelosi and Minority Whip Steny Hoyer, voted against it, but all 3 of the Republicans voted to defend DOMA, and that's when they hired Paul Clement, George W. Bush's former Solicitor General, to defend the law at one of the 2 law firms that he's been at since undertaking that representation, and they've moved forward, and for a while, what the Justice Department was doing was just filing that February 23rd letter in the cases, and that's what they did in the First Circuit with the Gill case that was brought by gay and lesbian advocates and defenders. They just filed the February 23rd letter and attached it to the court and said, we're no longer defending DOMA. But what they did on Friday, on July 1st, that was so remarkable was that rather than filing this 5-page letter with the court, they filed a full brief, a 31-page brief that went through all of the reasoning for both why heightened scrutiny should apply to sexual orientation classifications, and also why, under that heightened scrutiny, the Defense of Marriage Act can't be constitutional. So they effectively took Karen Galinsky's side in this case, looking for health benefits, the same for her to give to her wife as a man working for the federal courts would be able to give to his wife.
So this happened just right after, very significant political things were happening. You were here in New York covering the president's speech as he was raising money at the gay TM here in the city. Less than 24 hours later, I was in the Capitol here in Albany when Governor Cuomo, after the Senate passed it, was creating New York marriage law. And it seemed like the president was really parsing things politically. But then at some point over the weekend, I think your hashtag was OICWYDT. So, I see why you did that?
I see what he's doing.
What he's doing, okay.
I see what you're doing.
And this was after this Galinsky filing, which you wrote that it is the single most persuasive legal argument ever advanced by the United States government in support of equality for lesbian, gay, and bisexual people, which is pretty strong. So why is it the most important, do you think? What was it about this?
I mean, it is the first time. I mean, first, the really the most remarkable sentence in the whole piece was where they said the federal government has played a significant and regrettable role in the history of discrimination against gay and lesbian individuals. That's the argument that Lambda Legal, that gay and lesbian advocates and defenders, that NCLR have been making for decades. And now the Department of Justice has said, this has happened. And not only did they say it happened, but they called it both significant and regrettable. This gets you it does a lot of the brief does a lot of the footwork for courts who are looking at this question of whether sexual orientation classification should get heightened scrutiny, and to do so as the government adds this level of just reality to it that it doesn't necessarily have when the argument's made by a lawyer. And I think any lawyer arguing any sexual orientation case is going to be quoting from this brief and from any like it that follow.
So regardless of where the president and the attorney general maybe are speaking politically, are they really laying out a case for full legal equality through responsible legal channels?
Yes, I think that they are, and I think one of the areas where the administration, where Obama's comments specifically have gotten him some of the most heavy criticism in the past 2 weeks, has been this question of states' rights.
Right. And, that's just, from my standpoint, to hear our first black president sort of carrying on about states' rights just politically seems very odd, but there is obviously a legal argument for doing this.
Well, and the problem, and he kind of got into it, I think he had sort of, they had undermade his case on Thursday when in his speech that he gave in New York. But if you look at what he said on Wednesday at the news conference, like 6 days later, he really laid out the case for the fact that this heightened scrutiny that they're talking about in the DOMA cases also applies to these state considerations. He wants and thinks it's a good thing for states to be debating these issues and to be having conversations, to be having discussions. And I think that what he started to explain on Wednesday is that if sexual orientation classifications are subject to heightened scrutiny, then there are limits to how those state debates can come out. And in this brief on July 1st, what the Department of Justice did was they actually went through and listed like more than 20 examples of state discrimination against gays and lesbians.
What was the most significant one that jumped out at you?
Well, actually the most significant one was that they after detailing the history of state regulations against teaching, against adoption, they then specifically talked about Romer versus Evans, which was the 1996 Supreme Court case striking down Colorado's Amendment 2 as unconstitutional because it didn't allow participation in the political process by gays and lesbians, because it eliminated the possibility of any city passing a non-discrimination ordinance based on sexual orientation. And then immediately the next paragraph after talking about Romer versus Evans, the Department of Justice then raised this issue of the Tennessee law passed in May.
Oh, so that's how recent, yeah.
And so this was the Department of Justice basically saying, I mean, explicitly, that there are still examples of anti-gay discrimination going on now by states, and that includes this law in Tennessee. So even though it wasn't a brief filed in the lawsuit being brought against that Tennessee law, I think you're going to see that paragraph in the lawsuit that Abby Rubenfeld and other legal organizations have brought challenging that Tennessee law, because that's a remarkably powerful statement for the federal Department of Justice to stick into this brief to give to those people challenging the Tennessee law.
Wow. So what do you think?
I mean, it's really remarkable.
So what do you think, what happens from here in the next, legally, in the rest of the political calendar? I mean, you were just writing today, right before we got to Skype together, that there was another filing that you were writing up that had a decision that come out today?
Yeah, there was another order in an immigration case today where a same-sex, I mean, this is one of the big things has been just the for those people who aren't aware of all of the impact of DOMA on same-sex couples, I think that people are really being given an opportunity to see it in the ripple effect from this February 23rd letter. And one of those places has been with same-sex binational couples who, because of the Defense of Marriage Act, even if they're legally married after Massachusetts in 2003, even if they're legally married, they haven't been able to they haven't even been able to have their green card applications based on that marriage considered because of DOMA. And a lot of immigration judges and even Attorney General Eric Holder have sort of raised questions about, well, if DOMA is unconstitutional in the administration's view, how should we be viewing these cases? And there was another example of that today, and an immigration judge in Baltimore said that in the interests of justice, she was reopening this immigration case in order to consider these issues.
In the interest of justice, that's another clause you'll probably be hearing a lot.
Yes.
In your background as a lawyer and a journalist, do you think that it's as likely that Galinsky will be able to potentially successfully sue for parity in her federal job, and that could be the doorway to federal rights like immigration, as likely as if it was just fighting about immigration directly?
Well, I think that there are a lot of challenges to Section 3 of DOMA, to this federal definition of DOMA, that from the tax code to Edith Windsor's case in New York, talking about the estate tax, inheritance tax, to these immigration cases, to if you go through the various GLAD cases in the First and Second Circuits, there are all of these 1,100, 1,300 federal benefits. At some point in these marriages that are happening in the 6 jurisdictions, now 7 once New York starts, these benefits are being denied. That it's really happening to real couples, and every time there is a benefit that's denied, that is another possibility that that person's going to say, I that shouldn't be denied to me. And especially after the first DOMA Section 3 case in the Guild case in Massachusetts, a lot of couples aren't going to say, well, this is fine. I mean, look at the bankruptcy case in California, where the gay married couple filed a joint bankruptcy petition. That wasn't a case that was being run by the LGBT legal organizations. It was a case by somebody who wanted to file bankruptcy.
Right.
And so these problems are just going to be raised.
All right, well, thank you for helping us try to navigate a little bit through the labyrinth of overlapping jurisdictions and state and federal issues. There's a lot legally going on, and I appreciate the way that you try to make sense out of sometimes the nonsensical.
Well, and they'll just keep going.
All right, thank you very much, Chris Geidner of Metro Weekly and the Polyglot blog. Bye-bye.
Bye-bye.